Ron Poliquin, DoverLawOffice.com, your Delaware employment attorney. I'm coming at you today because I wanted to explain the difference between the fee arrangements that you have, that clients have with attorneys. Basically, there's three, for the most part with employment law, there's three types of fee arrangements. There's the hourly fee. Hourly, right? That basically means what will happen is the client will give a retainer amount, which will be put into a trust fund. Sometimes that'll be $4,000, can go up to $8,000, depending what type of case. Retainer, it'll go, let's say you put what will happen in the beginning of the case, $4,000, let's say that's what the retainer is. $4,000 will go into a trust fund that the attorney has that's separate, that he cannot touch. He cannot touch that trust fund until he's actually earned that money, okay? And he usually bills hourly. And what will happen is each time you get the client will get a statement, maybe at the end of the month, saying, I billed 5 hours, let's say it's $300 an hour, $1,500 was taken out of your retainer, this is the amount you have left. And once that retainer amount is done with, then the attorney will ask for that retainer amount to be replenished with usually the same amount of money, if not some more. So let's say first month, initial $4,000 is the initial retainer, okay? So let's say the attorney earns $2,000. All right, so the remaining amount would be $2,000 in the retainer, okay? And at that point in time, you'll see that it should have an hourly rate. It should say 0.45 hours spent on this, 0.3 hours spent on that. It should be a complete breakdown. And the attorney earns that before he takes it out of your retainer trust account, okay? Obviously, with employment law, that can be not practical for someone who's just lost their job. So there's other types of fee arrangements that can be worked out. All right, let's say there's the contingency fee. This is the classic fee arrangement where the attorney does not get any money. It's not based on hourly. It's usually based on a percentage of whatever he recovers for his client. Meaning sometimes it's a third, sometimes people make it 33 1/3, plus cost, meaning cost would be taken out of the client side of it. The client would be responsible for cost, but that'll all come out of the ultimate award, okay? So let's say the settlement's 15 grand. I know, this is bad handwriting, it's all messy, got it. I think that's close to 5,000, but it might be 495 minus $500 in cost. And whatever that would have come to, that's ultimately what the client would get at the end of the day. Now, if the attorney recovers nothing, then he gets nothing. There's also a third type of a contingency type of fee arrangement. It can be a hybrid, meaning it's a cross between contingency fee, it's real exciting stuff, eh? An hourly fee, or an hourly retainer. Meaning, there are times when an attorney will say, I want the client to have some skin in the game, so let's say he charges an initial $2,000 retainer, and there'll be contingency after that. Might be $2,000 to review the case, write a demand letter, could be to represent the client throughout the Department of Labor or EEOC investigation. And then maybe you work it out where there's a contingency fee. Let's say you recover 20 grand, $20,000. Awful handwriting, this is bad. But 20 grand, and you take the contingency out of that, but you at least put up $2,000 for initial retainer. I was listening to a podcast recently with famed attorney Mark Garagos. He said, He put it like this: if your attorney wants to take it on a contingency fee basis and is eager to do it that way, that means he really believes in your case. If he takes it on a hybrid basis, that means he kind of believes in your case. If he takes it on an hourly basis, he doesn't believe in your case at all. I don't think that's quite true. There are all sorts of reasons why an attorney would take on, would decide a different fee arrangement. Some attorneys just will do hourly, that's it. Some attorneys will always do contingency fee. Most attorneys do not like to have all contingency fee cases, so it just might be a timing thing. Because attorneys have cash flow issues and cash flow, so they might need $2,000 to get them through to justify working on your case. They might also be flush with cash, so they're willing to take it on contingency fee, and they are really hyped up on your case. They really believe in it. And maybe that's just you really believe in your case, but the attorney doesn't see a lot of money in it for him, or their limited damages at the end of the day. So he charges an hourly case. That can happen. Hourly fee. There's all sorts of reasons, but be sure to read over the fee agreement, discuss the fee arrangement with your attorney, make sure you understand, especially with the hourly rate, that $4,000, $5,000 gets used up fast. You're going to be responsible for replenishing it. Ask your attorney, how much do you think this case is going to cost from soup to nuts, so you have some kind of idea. Anyways, that's Ron Poliquin, DoverLawOffice.com. Shoot me a question. I'd be happy to answer it on one of these videos. Thank you.